Welcome, and thank you for joining us. Please note that this AI-generated podcast is intended solely for general learning and educational purposes. While we strive to ensure accuracy, the AI may occasionally produce errors or incomplete information. We strongly encourage you to consult qualified professionals and conduct your own due diligence before making any legal, financial, or business decisions based on the content presented here. Also, if you find this content valuable, we kindly request you to like the video, subscribe to the channel, and activate the notification bell to receive updates on future episodes. Let's begin.
Welcome to the Deep Dive. Today we're jumping straight into, well, frankly, the future. We're looking at a really critical intersection between truly revolutionary tech quantum computing and a notoriously skeptical area of law, patent eligibility.
Yeah, this is a big one, a decision many in R&D and IP law have been, keeping a close eye on. We're digging into the September 2025 ruling from the Patent Trial and Appeal Board, the PTA, and it boils down to a pretty fundamental question, doesn't it?
It really does.
If you use a quantum computer to solve an old, known financial problem like risk assessment, is that inherently patentable, or is it still just applying tech to an abstract idea?
That's exactly the heart of it. And the stakes, well, they're massive, especially for big financial players like S&P Global Inc. They're the real party in interest here, backing the inventors, Yili Zhang and their team. We're really asking if this quantum leap in sheer power translates into a legal leap for patent protection.
Precisely. And this all centers on 35 U.S.C. Section 101. Now, for listeners, that might just sound like a code section, but it's the gatekeeper. It decides what kind of thing can even be considered for a patent, filtering out, laws of nature, natural phenomena, and the big one here, abstract ideas.
Okay, let's unpack this then. Get into the nitty-gritty. We're looking at Appeal 2025-000611. It concerns application number 17,651,277. And this was decided by a PTA panel, Judges David M. Kohut, who actually wrote the decision, James R. Hughes, and Matthew J. McNeil.
Right. And the appellant's lawyer was Duke W.U. So that sets the stage for who was involved.
Got it. So what about the timeline and the core facts? How did this specific dispute come about?
Well, the application itself, it was filed back in February 2022. It described a computer-implemented method for calculating risk. That's the core. And it used what they called a quantum rating framework.
Quantum rating framework.
Yeah.
Okay.
Now, here's a really crucial piece of context, something that shaped the entire appeal. Initially, the patent examiner rejected all the claims, that's claims 1 through 24, under both Section 101 for eligibility and Section 103 for obviousness.
Ah, the double whammy. Pretty common initially.
Very common. But then something interesting happened. The examiner withdrew the Section 103 obviousness rejection.
Oh, so they effectively conceded the invention wasn't obvious, that the technical aspect, the quantum part, was genuinely novel and non-obvious.
Exactly. That's huge. It means the technical merit, whether it was a clever way to use quantum circuits for this task, wasn't really the issue anymore. The USPTO basically said, okay, it's not obvious.
Which leaves only Section 101.
Precisely. The entire fight shifted solely to patent eligibility under 101. Was the subject matter itself eligible for a patent, regardless of how non-obvious the implementation was?
So the legal question became much sharper, almost philosophical it was. Is this method for calculating credit risk using these N-qubit quantum circuits to generate stochastic quantum values, is that directed towards an abstract idea, something inherently unpatentable?
That's the crux of it. They had to weigh the novelty of the quantum hardware against the long-standing nature of financial risk calculation.
All right, let's get into the arguments. We need to look at the Alice-Mayo framework. Step 1. Is the claim directed to an abstract idea? How did the appellant, Zhang's team, argue against that?
They had two main lines of attack against that Step 1 finding. First, they argued Claim 1 wasn't about organizing human activity. They said, look, it's all done by a computer, specifically a quantum computer. There are no human steps recited.
So they were trying to say abstract ideas under 101, at least in this context, require some kind of direct human organization or mental step.
Kind of, yeah. They seem to be pushing back against classifying purely computational methods as inherently abstract in the same way, say, a business method performed by humans might be. Their second argument, though, was maybe more direct.
What was that? Focused on the tech itself.
Exactly. It was purely technological. They said, you can't call this a fundamental economic principle because it requires these novel N-qubit quantum circuits. Quantum computing isn't old, it isn't well known in practice, so how can a method depending on it be fundamental?
That sounds like a pretty strong point on the surface. I mean, how can something needing this cutting-edge, almost experimental hardware be fundamental in the way, say, hedging risk with basic math is?
You'd think so. But the PTADE, leaning on the examiner's reasoning, wasn't buying it. Their counterarguments were, well, pretty firm and grounded in precedent.
Okay, what was the board's response? How did they shoot down those arguments?
First, on the fundamental practice point, they agreed with the examiner. The claim is directed to the abstract idea of determining a credit risk rating, full stop. They even pointed to the appellant's own specification, which described the goal as, and I quote, deriving a credit rating for a financial instrument.
So they used the inventor's own words against them.
Pretty much. They said the lack of explicit human steps doesn't matter. The underlying concept is calculating risk. And that's a fundamental economic practice. Doesn't matter if human does it, a classical computer or a quantum computer. The what is abstract.
Okay, so the tool doesn't change the fundamental nature of the task being performed,
Yeah.
in their view. What about the novelty argument? The fact that quantum computers aren't old or well-known?
Yeah, they tackled that head-on too. Citing cases like OIP technologies, the board basically said, fundamental doesn't necessarily mean old or well-known. It refers to foundational economic or business practices, these basic building blocks. Think hedging, accounting, or like here, assessing risk.
So using a brand new revolutionary tool, even a quantum computer, to do that fundamental thing doesn't make the thing itself non-fundamental or non-abstract.
Exactly. The newness of the tool doesn't rescue the abstractness of the underlying practice. That pushed the analysis firmly into step 2 of Alice Mayo.
Right. Here's where it gets really interesting.
Yeah.
Step 1. Okay, it's directed to an abstract idea, calculating risk. Step 2. Does the claim add significantly more to transform that abstract idea into a patent-eligible application? This is where the quantum part really had to shine, right?
This was absolutely the appellant's crucial battleground, and they made a strong technical case here. They argued the quantum features were significantly more. They even compared it to the invention of the transistor, calling it a key technological-based building block.
A fundamental component that enables entirely new capabilities.
Precisely. They emphasized that the quantum circuit wasn't just faster. It fundamentally changed the scale of the problem you could tackle. It allowed processing, and this is key, exponentially large quantities of information simultaneously in only polynomial time.
Okay, let's pause on that. Exponential information in polynomial time. For someone maybe not deep in computational theory, what does that translate to in practical terms for, say, S&P calculating credit risk?
It means, imagine trying to model the risk of a huge portfolio. With classical computers, maybe you can handle, 10, 20 interacting risk factors realistically. You hit a wall pretty fast.
Right, the complexity explodes.
Exactly. With this kind of quantum approach, theoretically, you could model thousands, maybe millions of interconnected correlated factors almost instantly. Things that would take today's supercomputers years or just be impossible could potentially be done in minutes or seconds. It's a different class of computation.
That sounds pretty significant. A qualitative leap, not just quantitative speed up.
That was their argument. They said this isn't just doing the old thing faster, it's enabling a new level of analysis. That has to be significantly more, right?
You'd think so. But the PTAB's final decision.
The PTAB affirmed the examiner's rejection of all claims 1 through 24.
Wow. So even that massive computational advantage wasn't enough. What was the board's reasoning? How did they justify saying that wasn't significantly more?
They fell back on a critical distinction, one that's frankly tricked up a lot of software and computation-related patents. It's the use versus improve test.
Use versus improve. Okay, explain that.
The board essentially asked, does this invention improve the functioning of the quantum computer itself? Or does it merely use a quantum computer as a tool to perform the abstract idea of risk calculation more effectively?
Ah, I see. So are you making a better quantum computer, or are you just using a known quantum computer to do fancy math faster?
Precisely. And the board concluded it was the latter. They found that the claimed benefits the incredible speed, the ability to handle massive data sets, the polynomial time processing these are inherent known properties of quantum computers in general.
They weren't benefits invented by Zhang and his team specifically for this application.
According to the board, no. They were benefits you'd expect from applying any suitable quantum computer to this kind of complex calculation. The claim simply took the abstract idea, risk calculation, and said, do it with a quantum computer. It didn't claim an improvement to quantum computing itself.
It's like using a faster car to deliver pizzas. You haven't invented a new way to make or deliver pizzas, you've just used a faster known tool.
That's a good analogy. The board felt the claim was just linking the abstract idea to a particular technological environment, the quantum computer using it as essentially a generic component, albeit a very powerful one.
What specific court cases or precedents did they rely on to make that use versus improved distinction stick, especially in the context of computation?
They pointed to some key Federal Circuit cases that have really defined this area. Cases like BSG Tech LLC v. by Seasons, Inc., and also Interval Licensing LLC v. AOL, Inc. These precedents establish that merely automating a known practice or speeding it up using generic computer components, even advanced ones, isn't enough for eligibility.
And credit acceptance court often comes up too, right? About automating fundamental economic practices.
Yes, exactly. That line of cases says if you're just making a known business or economic process faster or more efficient via computerization, you haven't added the significantly more needed to overcome the abstract idea hurdle.
This seems like a very clear ruling then, even if it's tough news for inventors in this space. Was there any disagreement among the judges? A dissent, maybe, arguing the sheer power of quantum should count as significantly more?
No, the decision was unanimous. All three judges, Kahoot, Hughes, and McNeil, agreed on the outcome and the reasoning. No separate concurring or dissenting opinions were filed.
Wow, complete agreement. That sends a pretty strong signal.
It really does. It suggests the PT is quite aligned on how to apply the existing Alice framework, even when faced with something as potentially game-changing as quantum computing.
So let's talk about the broader impact. What is the real legal significance of this ex parte Yili Zhang decision? Why should companies, inventors, investors care?
Well, its significance is huge, primarily because it's one of the first major PTAB decisions applying Alice directly to quantum computing claims, especially those tied to fundamental economic practices like finance.
It's a benchmark then.
Absolutely. It sends a very strong signal from the Patent Office. Simply swapping out a classical computer for a quantum computer to do the same underlying task, even if it does it exponentially faster or better, is likely not enough to get you a patent under Section 101.
So for companies like S&P Global pouring money into quantum applications for finance, what's the message?
The message is, your invention needs to be in the quantum computing itself, not just using the quantum computer. You need to demonstrate an improvement to the quantum algorithm, a novel way of mapping the problem onto qubits, a new error correction technique specific to the application, or maybe even an improvement to the quantum hardware integration.
It forces the focus away from just let's use quantum speed towards let's genuinely advance quantum science in the context of this problem.
That's a perfect way to put it. The invention has to be in the how of the quantum computation for that specific task, not just in the fact that you're using a quantum computer.
Okay, so boiling it all down, if you had to give just one single, most important key takeaway from this entire decision, what would it be?
The number one takeaway, I think, is crystal clear. The novelty of the computational tool, even if it's a revolutionary quantum computer, does not automatically save your claim if the underlying method is abstract, like a fundamental economic practice.
The tool doesn't sanitize the abstract idea.
Exactly. You can't just point to the fancy hardware. The inventiveness, the significantly more, has to be found elsewhere, typically in how you're configuring or improving that hardware or the specific process running on it, beyond just leveraging its inherent capabilities.
So what does this all mean for you, the listener, especially if you're involved in tech innovation? This ruling really forces a critical question, doesn't it? When you're designing something using next-gen tech like quantum circuits, you have to ask, is my core invention about making the task, like risk calculation, better by merely using a faster tool, or is it about making the tool, the quantum computer or algorithm, better for that task?
That's the fundamental divide.
And as the PTK made clear here, the answer to that question could very well determine whether your groundbreaking work is actually patentable, a really crucial decision to understand. So thanks for diving deep with us into this quantum risk ruling.